Tip-top, top of the morning to you. It's Wednesday. It's hump day. Today's the 15th. I haven't been particularly active online the last couple days, and I apologize about that. A lot going on at work. Going to work early, getting home late. Busy right now for me. I'm a busy little bee. I didn't like me walking past it. Had really disappointing news in two cases yesterday. It's a sobering fact to lose when everything seems to be going your way. Reality is a harsh mistress. Lawyers are wrong 50% of the time. I'm sure I'm going to get poo-pooed over admitting that, well, technically it wasn't me, but that guy circled twice. The one headlight guy right there. I have no idea what's going on with that. Yeah, you could have a winning case on paper and still lose. One of them was a domestic violence restraining order. Had pictures of our client all bruised up and battered. But amazingly enough, she was a terrible enough witness. Terrible witness. Oh, good Lord, was she a terrible witness. She argued with the judge. She argued with my boss, who was the one who was asking her questions. She argued with opposing counsel. She was just a terrible witness. And at the end of the day, if the judge in a domestic violence restraining order case is the finder of fact, at least in California, if he doesn't believe your testimony and he doesn't believe you, then he's not going to believe the pictures of you all battered. He's not going to believe anything. So that was terrible. A lot of people in the comments, oh, the first duty of an attorney is to the court. Not really. First duty of an attorney. There is a duty owed by the attorney to the court to not file frivolous actions, motions, whatever. It either has to be supported by the law, or you have to be able to make a good faith argument that it should be supported by the law. And if you can't do that, then you shouldn't be wasting the court's time with it. So the attorney does owe the court that duty. He also owes the court a duty to be professional and all that fun stuff. But the client's real duty, his first duties to the client, attorney's first duties to his client. Trying to win. You want to win. That's what you get paid to do. That's what you want to do. That's how you're judged. And to me anyway, it's very unsettling to lose. The other one was it was just a motion. We wanted judicial determination that a mother had waived the therapist-patient privilege for her child, and we wanted to depose the therapist. And the therapist was saying, I'm going to assert the privilege. Well, the mother had submitted a declaration by the therapist. It had been submitted into court. That's essentially testimony. That's evidence. That is something that the finder of fact is going to use in making their determination. And we expected, we demanded the right to cross-examine. You don't get to just submit a declaration to the court and the other side has to just live with it. Opposing party gets to cross. So we brought the motion in front of the judge, and letter of the law is just, black letter of the law. We get to cross. We get our shot at that witness. And I guess this was all my fault, so I picked a bad strategy. But in arguing the motion in front of the judge, I knew I had black letter of the law on my side. It was just, there just was no doubt. And the judge was asking about, well, what about the child's interests? And the child doesn't get to, because in California, if a holder of the privilege waives that privilege with regards to a communication, then for that communication, the privilege is waived. And the mother waived the privilege, and she, as with 100% legal custody of the child, she waived the privilege. And amazingly enough, we got yesterday afternoon, the motion was denied. And the judge really went out of his way to make sure that motion was denied. He said basically that he had already done an evidentiary hearing. He hadn't used that declaration. So that declaration, while it was submitted to the court, it was not in evidence. So we don't get to cross. I am flabbergasted by that one. That is about the most amazing thing I've ever seen. Now, admittedly, I'm new to this whole lawyering gig, but that is just, talk about wow. It was submitted to the court, but the court didn't use it in evidence, so it wasn't submitted into evidence. Oh my God. Oh my God. So anyway, I think that was pretty terrible. I wasn't happy about that. Still not happy about that. My boss says I shouldn't take my work home with me, but I do. It's hard to, you beat your head against the rock of that, whatever you're trying to do, until either the rock gives or your head gives. And you just lay there tossing and turning, thinking about woulda, coulda, shoulda. The judge had asked me if I would stipulate to only bringing up the things that were expressly mentioned in the declaration during the deposition. And thinking that I had the law 100% on my side, I said, well, Your Honor, we need to know the underlying facts and analysis that the therapist was using in coming to these conclusions. So, well, our goal is to stay within that realm and not explore all avenues of the child's psyche. But I wouldn't stipulate, and that was dumb. My boss told me that was dumb. He said it doesn't matter. The judge can craft the order however he wants. And you were dumb to not stipulate. And I was dumb to not stipulate. Still kicking myself in the butt over that one. People think that, I don't know, maybe some lawyers are. I'm not. I really get invested in dealing with my clients, and it really sucks. It really sucks when you can't make it right for them. When you've taken all this money and you still lost, I feel terrible. Well, anyway, the case with that we're working on, the motion that was denied, that one's still ongoing. So who knows? Maybe we can pull a rabbit out of a hat for our client. The domestic violence restraining order case, that one's done unless we appeal it. And an appeal would be for abuse of discretion. They would preserve the findings of fact of the lower court judge. Again, unless we pull the magic rabbit out of a hat. And because the lower court judge found the testimony of our client to be uncredible, and since that testimony, in his opinion, cast doubt on every other piece of evidence that she submitted. Oh my God. Anyway, that's been my week. How's yours been? Anyway, I guess that's about it. I've vented enough. Thank you for being my therapist this morning. I got another long, full day ahead of me today and tomorrow. On Friday, I'm looking forward to a contempt hearing. Not me. I'm not. It's sanctions, basically. We've asked the court for sanctions on opposing counsel in the case we're doing out of San Mateo, and that case is at 9 in the morning, so I'm going to be bebopping out of my place at about 5 in the morning to drive down to San Mateo to be there in time for the hearing. So that's going to be fun. Instead of getting up at like 4:15 and going for an hour walk, I'll probably end up getting it up at like I don't even want to think about it. Anyway, thanks for watching. Have a great day.